With that, we'll call the first case, Alice Brown versus City of Sault Ste. Marie, a case involving notice under the Governmental Immunity Act and whether notice can incorporate by reference documents outside of that notice. Please proceed.
Good morning. May it please the Court. Hillary Ballantyne on behalf of defendants' appellants. Seated with me at counsel table is co-counsel Robert Kamenak. I will waive any free fire zone, but I would like to reserve 3 minutes for rebuttal, please.
Okay.
Defendants request that this Court peremptorily reverse the Court of Appeals opinion and reinstate the grant of summary disposition to defendants, or alternatively, grant leave to appeal. The precise issue before this Court today is whether the Court of Appeals erred in concluding that the requirement of MCL 691.1404 subsection 1, namely that the notice shall specify the injury sustained, is satisfied when, read as a whole, the notice merely states that the plaintiff suffered, quote, severe and permanent injuries, end quote, but references FOIA documents not attached and with respect to another notice requirement. The answer to that question is a resounding no. There are 4 reasons why the Court of Appeals opinion is in error. First, it is inconsistent with the plain language of the statute. Second, it thwarts the purposes of the statute. Third, it adopts an actual prejudice requirement, which is contrary to this Court's precedents. And fourth, it applies a notion of substantial compliance that this Court has expressly disavowed. With respect to the first reason, the plain language of the statute states that the notice shall specify the injury sustained. This means, under a plain reading of the statute, that the 4 corners of this written document must identify clearly and precisely the injury. In Rowland, this Court held that the language of the statute is clear, unambiguous, straightforward, and must be enforced as written. The Court of Appeals did not do that here.
Counsel, good morning. You know, it's funny, I just want to kind of jump in. First off, Happy New Year. Welcome to the Court.
Thank you. It's a pleasure to be here.
If it's okay, I want to kind of ask you kind of a more kind of profound question, if you could, just to kind of get our conversation going. And the question that I'd kind of like you to try to answer for me, and that I have been thinking about and pondering about as I've kind of spent a lot of time on this case, help the Court to understand, how is it that your client was aggrieved? You have a pretty significantly injured party, a party that fell 10 feet, which is a very substantial amount, into a hole, was horribly injured. And you're asking for this case to be dismissed on the specificity of notice. And what I'd like you to do is I want you to explain to the Court what exactly is the injustice that you are feeling that Sault Ste. Marie has sustained as a result of how the plaintiff filed this case.
Sure, Justice. I think the best answer to that question is that the Court did not, or the plaintiff did not adhere to the plain language of the statute, and they referenced documents, and they didn't even reference documents with respect to the nature of the injury sustained, and I think it's important.
But these were documents, and I think, like, when I try to think about the justice of this,
right,
it's ironic because you have to admit, these are documents that were in your possession. Is that not correct? These are documents that were FOIA'd by the plaintiff, but you're arguing that he didn't reference documents when these were the very same documents that the City of Sault Ste. Marie has in its possession. Am I not correct?
I would say 2 things to that, Your Honor. Yes, they were documents received in response to a FOIA request, but what the plaintiff here is asking...
But just understand, so he FOIAs them.
He FOIAs them.
Just because you have to look at this kind of in a more, it's just the perspective I'm trying to use to understand this. Mm-hmm. So the plaintiff's attorney FOIAs the documents from you. You then give him the documents, and then you're arguing that he didn't submit the documents that you gave to him.
Because
in a correct fashion.
What happened is that the government here was required to guess what information the plaintiff was trying to pull from those FOIA documents to satisfy the statutory requirement that the injury sustained.
It's a police report, it's an ambulance report, and you had to guess, but it was the same person that actually was responsible for giving him the FOIA material that he sent back. This is the person who gave him the information, then he then sends it back to the same person who gave him the information in the first place, and you're arguing that this is unjust to you because you had to guess when it was the very same person who sent him and honored his FOIA request to start with.
Knowledge of institutional facts is not the equivalent of providing those facts in a written notice, and this court made that pronouncement in the Smart case. And here, the government should not be forced to go on a scavenger hunt to look through police reports and document reports.
The same police reports that you sent to him in the first place.
Correct, but there's a lot of information contained in those reports.
Do you mind?
Of course.
Of course.
I think what you're, I mean, I assume what I assume one response to Justice Bernstein might be, we're prejudiced because the language of the statute requires, at least you said the plain language requires the notice specify the injury, right? So I just want to get back to asking, I think, what are some similar questions, but in the context of what you're arguing. I guess what would you have done differently if the notice had said, if the letter itself, not referencing the FOIA documents, had said that the severe and permanent injuries were to the plaintiff's head versus the plaintiff's leg? Like, would the city, understanding sort of the purpose, you said purpose was the second of three reasons why the court should take action here. And I read Roland again to remind myself why why the notice statute is important, and what would you do differently if the serious and permanent injuries were to the plaintiff's leg versus head? Would you
if the notice had said that there was a severe and permanent injury to the leg? Well,
I'm just saying that you complained about the notice saying severe and permanent injuries, but not to a specific body part, I guess, is the...
Well, the injury sustained has to be set forth clearly and precisely. So even if
Well, it says specify the injury sustained. Clearly and precisely is, you're adding that. But.
Well, clearly and precisely is the plain language definition of specify.
Okay, specify, but what needs to be clearly and plainly described?
The injury,
the nature of the injury, the body part, or the severity?
The body part, the nature of the injury, and I would argue also the severity. Because
so all three?
Right, because the whole purpose is, and I think what the Court of Appeals here forgot, is that the purposes of the statute are not just to allow the government the opportunity to investigate and repair the defect. They're also to allow the government to properly set reserves.
So that's what I was going to get at. I could imagine if you're setting reserves, especially in the small. I mean, I looked up the budget of Sault Ste. Marie. It's not enormous. I mean,
right.
You do have to plan for things like this.
You
right?
do, and it's.
Just let me finish. So I could imagine, it would be important to know if an injury was minor and not going to be very expensive, or quite significant and might be very expensive if, in fact, the city is at fault, which is a different issue down the line. That we don't have to figure out today.
Correct.
But so again, why does whether the serious injury is to one body part or another make a difference in the setting reserves?
Well, it makes a difference. I mean, for example, here, the EMT report referenced many things. It referenced a facial laceration. It referenced a head wound. It also referenced pain in all the extremities. It referenced nausea. So it's impossible to know what the injury is that the plaintiff is claiming. And the plaintiff is the one who can fix the claim. The plaintiff is the only one who can do that. And the government should not be forced to guess, as it was here, even with documents provided in response to a FOIA request, as to what the nature of the injury is.
So why did you
complain about it? I
thought
in
the notice
statute.
was unbelievably deficient in terms of notifying you where the exact location of the injury was. And the statute, the plain language of the statute, is even more demanding in terms of location. It says exact location, right?
Correct. Exact location and nature of the
letter, I mean, the FOIA documents obviously make it clear, and I assume you did know where it happened. But why didn't you complain about that?
Well, Your Honor, that was a strategic decision made, but that doesn't allow the plaintiff to circumvent the other requirements of the statute. And I think that's what the
it does. I'm just trying to understand. Did you believe that the FOIA documents were sufficient on the exact location of the injury and on the witnesses? Because you didn't complain about either of those.
I would argue no, but we chose, for strategic reasons, not to challenge that. And what the Court of Appeals got into, and what's important here, is that there's no actual prejudice requirement here. And that's something that has been judicially engrafted on by the courts. It is not consistent with the plain language of the statute or the purposes of the statute. And when you have this actual prejudice requirement, which is what the court has done, it is in complete contrary to this court's precedents, first in Rowland, which said there is no actual prejudice requirement, and in McCann, which it reaffirmed. So
would it make a difference if the documents were attached to the notice?
I think it's closer, but no, it's still insufficient.
I just want to refine that a little bit. In that instance, I think Justice Viviano is bringing in the Plunkett versus Department of Transportation case.
Correct.
And Rule versus Bay City. So what do we do with those Court of Appeals cases?
Well, I
if
think
you were
Plunkett
writing
was-
this opinion, how would you write it?
If I were writing this opinion?
Yes. Would we have those Court of Appeals precedent? Would we adopt it? Would we disavow? What would you do?
You would disavow Plunkett and Rule versus Bay.
On what basis?
On what basis is that there is no strict compliance. There is no strict compliance found in the language of the statute, and that's what the Plunkett court said, that there's substantial compliance. There is no substantial compliance. And so the Plunkett case was completely incorrectly decided. It should be disavowed.
Was Plunkett wrong on looking at documents that were attached to the notice? Is that okay to do, or is that not okay? We're here trying to make rules
Right.
of general applicability everywhere in the state. So does the notice have to be a single piece of paper? Does it have to be on a postcard? Does it have to be in an email? I mean, what's the form of the notice that we should look for? Or is it okay if certain things are stapled to a document? Is that okay, or is that not okay?
If there's documents attached and they supplement the notice, then that might be okay. For example, if you have a situation where the notice
Well,
sets
let's
forth...
talk about this case. If the police report and the ambulance report were stapled to the notice instead of referenced as being documents in your client's possession, would that satisfy the notice requirement?
No, it would not satisfy the notice requirement.
Why not?
Because, again, it left the government to go on a scavenger hunt to pull out what it thinks the plaintiff wants to pull out from those documents.
So the problem is not that there's a couple different things, right? It's not that your clients had to work hard to locate the document. You're not complaining about that?
They shouldn't have to, Your Honor. The plain language of the statute says that it has to be set forth in the notice.
You're talking about two different things, right? So your client, it could be, the city of Detroit.
Did you reserve 2 or 3 minutes?
3?
We're down to 3 minutes. You want to continue?
I would like
Okay.
to just finish on this one line. If it's the city of Detroit and it's, the response, the notice says it's a document in your possession, that's one thing. But if they reference a document that's known to your client and readily ascertainable by your client, that's a little different, isn't it? I mean, did your client have difficulty locating the FOIA documents that it had just served on the plaintiff?
I'm not saying that my client had difficulty locating the FOIA documents, but they had difficulty locating within the FOIA documents what information the plaintiff wants to extract from that and use that to satisfy the notice.
So I want to establish where we are. So it sounds like it's okay if it's attached to the document from your client's perspective or your perspective, and it's okay if the notice references a document that's known to the defendant and readily ascertainable by the defendant. Do you agree with that? Because you're complaining about now something else, which is within the documents, the information's not clear enough.
Can I please answer the question?
Sure.
It may be a closer question if documents are attached, if those attachments supplement and provide further clarity to what's already provided in the notice. Here, even if the documents had been attached, they would not satisfy the notice provision.
Thank you. Why don't you save your
Thank
minute
you.
and 40 seconds?
May it please the Court, good morning. Kirk Liebengood on behalf of Alice Brown. In 40 years of lawyering, I always tried to do what was the safest and the most efficient. And in reviewing the case law on the subject of the statute, it became clear to me that it's the minefields are everywhere. And one of them is if you fail to transcribe properly a record that the government gave you. So the safest way to avoid that error, so the government knows where to look, is to give them to reference their own documents. This was 19 pages, including graphic pictures of the scene, everything except my client's injury. The police officer who responded didn't include in his report a picture of her face. The ambulance records described her injury as a 8-centimeter laceration / evulsion noted to left side of patient's forehead. The police report, who less medically trained, identified the injury as a facial laceration. My concern here was to make sure that this notice came in within 120 days, because if there's anything Roland stands for is if you're late, you're done. Candidly, in this area of the law, plaintiff's injury, frequently you don't really know the extent of the injury within 120 days. I'm sure some of you would be surprised if I were to say that recently my client informed me that she's been diagnosed with a traumatic brain injury. Nobody would have known that within 120 days of these events. The most efficient way for the government to investigate these claims is to look at their own records. They're on forms that they recognize. They're prepared by officials that they trust, and it's the best way to respond.
Counsel, it would not have been difficult for you to describe at some level of detail your client's injuries, would it? I mean, presumably you met with your client. I don't want to get into any attorney-client privilege conversations, but presumably you had some in which your client described for you in some level of detail the nature of her injuries.
I must concur that if I had referenced the FOIA documents, that my description of her severe and permanent injuries is not adequate. But by incorporating the FOIA documents, and I might further point out that I indicated in the letter that these injuries were witnessed by the police and fire personnel. So I directed them to that section of the FOIA response. Sure, I could have described a head injury, but as I just explained, frequently that doesn't fully alert the defendant in this case to the nature and extent of the injuries. In this case, it wasn't enough, but it's what we had at the time. So I gave it back to them. So if there's a mistake about what was included, it was their own mistake because it wasn't included to start with.
How do you respond to the argument that the reports described a number of injuries, but the city would not know which injuries you were claiming damages for? In other words, it's not necessarily the case that you're claiming damages for every injury that's described in the report, is it? I'm
not sure why I wouldn't in this area. Any injury that is suffered it's not like a no-fault case where I have to reach a certain level of injury. So I'm not sure it wouldn't include everything that was mentioned in the reporting. The remarkable thing here is that there is no lack of knowledge on the city's part about what transpired here. The statutory purposes of conducting an investigation and solving whatever defect existed so that others weren't hurt was well accomplished before I ever met Alice Brown. They acknowledge in their briefing that their knowledge of the operative facts is not equivalent. So what we're trying to do here is close the courthouse door because they don't want to look at their own records. That's what they're trying to do here.
You say no lack of knowledge. That is, I think, a backdoor way to arguing they're not prejudiced, which has been rejected by this court in prior cases. And I understand in this case the same person who sent the documents received the notice, but this is a rule we're trying to make for the whole state. What if it is in Wayne County or the city of Detroit where one person has a job of doing nothing but responding to FOIA all day, and another person has a job of taking these notices, and the two have never met or will ever talk? The rule that you'd like us to apply in this case would be very detrimental to the city of Detroit in that case. How do we come up with a rule that's good for the entire state and stay consistent with our precedent?
I think those are reasons why you shouldn't grant leave in this case, because these facts are pretty unique. It's an unusual circumstance where the hazard is so profound that it's unmistakable, and that the investigation was conducted by a police and fire person simultaneously almost with plaintiff's injury. These are unique facts. And I might point out that in the course of discovery, the supervisor of the water department crew was directed by that same clerk to prepare a report because their carrier wanted to get the details. So there wasn't any lack of knowledge here. They were conducting an investigation and responding immediately because the circumstances were so profound. That's why I thought, well, here's your records. You already know all about this.
Does it almost create a catch-22 for a plaintiff in this situation based off their argument?
Well, I liken it to a chicken and an egg. They're the chicken, they laid the egg, and I gave it back to them. And so there's no mistake that it's the chicken's egg. And in order to avoid a Scrivener's error or overlooking something, because candidly I hadn't got medical records yet because this takes time. 120 days is not that long. On it goes. I mean, she didn't hire me the day after this happened. This took some time. So I did as much as I could, as fast as I could, to satisfy the statutory requirements without making a mistake, to end up here.
But I thought earlier in your argument you admitted you could have done a little bit better job, and certainly in the Court of Appeals argument you admitted that you could have done a better job.
Yes, I did. I could have taken some more risk to not make a mistake. It was the safest approach, I think.
If it was the safest approach, I don't think we'd be here.
I'm trying to understand the risk. You think if you were to specify the wrong injury, that would be a bigger problem? What?
I can't recite the unreported decisions, but there are cases where plaintiffs, the courthouse door's been closed to plaintiffs because of a mistake on the address by a couple, 3 numbers where the hazard was.
Yeah, the statute says specify the exact location.
There are cases where dealing with the insurance carrier responding to the information is not the same as dealing with the city. So providing information to an insurance carrier isn't the same, so it doesn't count.
Yeah, the statute says notice to the city, correct. Right. So far I'm with you. I'm still trying to understand what the risk is in giving more information.
Right. Putting the address down and reading it twice, checking it twice.
What would have been wrong with saying the police report identified that plaintiff had a very large and deep head wound?
Well, I guess what I would say in response to that is that I'm assuming that the city clerk, because she responded to my letter asking for the information, is able to read and had read the information that she sent to me. So she should have been aware of all these things and responding to the FOIA request. I know she was after I did some discovery because, as I indicated, the supervisor was working on an investigation.
Should it matter
the day of.
Should it matter to us that your notice does not reference the FOIA with respect to the injury? In other words, it doesn't say suffered the severe and permanent injuries that are described in the police report or in the ambulance report?
It does. If you read...
what am I missing?
Well, where I indicate that the police and fire and rescue personnel and police department personnel also may have seen conditions and witnessed the injuries suffered by Mrs. Brown.
That's where you're talking about witnesses.
Well, I'm also talking about injuries. Admittedly, I could have been more specific.
I mean, the reference to the FOIA is in the preceding paragraph where you're talking about witnesses, right?
Which includes the police and fire investigations. I think it's a unique set of facts in that I don't know what utility could be served by creating a statewide rule based upon a case that was immediately investigated by the defendant. I'm not aware of any reported cases where there's a reference to FOIA documents as a source of the statutory required information. That's all I have.
Thank you very much. You have 1:40 seconds of rebuttal.
Counsel, what's the standard by which we should judge whether the notice is sufficient? Do you agree with the standard that this court used in the Barabo case, which related to a charter provision from the city of Detroit that says that the whole notice and all the facts stated therein may be used and be considered to determine whether it reasonably apprises the officer upon whom it's required to be served, in that case of the place and the cause of the alleged injury here would be of the injuries that were suffered?
I agree with respect to that the court can look to the entirety of the notice, to the notice of a whole, but within that notice...
But are we looking also at whether it reasonably apprises?
No, I would say the notice shall specify the injury sustained, so it has to be more than reasonably apprises. It has to set it forth with some particularity, which is what the statute says.
So what's the rule? Justice Zarr was asking about an opinion that we might author in this case. What rule are you suggesting that we adopt that would lead to the outcome that you're looking for in this case, but that would be generally applicable to the next 100 or 200 cases that come along?
I think the best rule would be a reaffirmation of Rowland and McCann and say that the notice provision must be interpreted according to its plain meaning, and that
if we're just reaffirming those cases, then there's really no jurisprudential significance to this case, which would ordinarily lead us to deny leave because the case is unpublished.
Well, it's significant in that those cases didn't deal with a reference to documents. So it is important for this court to consider this case, whether in a peremptory order, reversing the Court of Appeals opinion and saying that mere reference to documents that are not attached and with respect to a different notice requirement do not satisfy the statute. Or failing that...
You're losing me on that because I thought when we talked earlier, you had agreed that documents that were attached and maybe even ones that are readily ascertainable in the defendant's possession would be okay if they were more specific. Is that not your position, though?
No.
Did I misunderstand?
If, for example, the attached notice says there's a defect in the sidewalk and it's a quarter-inch, it's a quarter-inch rise and fall, and then it attaches a picture and it says, see the picture. Then in that case, a picture speaks 1,000 words. So that's okay. But that's not the question that this court has to consider because we don't have documents attached. We have documents that are merely referenced, and under the plain language of the statute, that is not enough because it does not specify what the legislature intended that the notice provide to the governmental entity.
And the notice and the specification is, according to you, the nature of the injury, the severity or lack thereof, the degree of the injury, and the body part injured. Do you think that
Correct.
That's what the legislature, even though in other notice statutes, like the no-fault notice statute, it asks that you notify about the nature of the injury. It's just nature of. So then we know you got to tell us something about it. Here we just have to specify the injury, and so you think we have to read in nature, degree, and body part.
I think it has to be clear and precise, Your Honor. If it said an injury to the head.
I mean, in some literature, in medical literature, when you specify the injury, it's all about degree. So do you think it has to be degree, kind of injury, contusion versus, burn, and also the body part? Is that right?
Right. I'm not saying it has to specify a third-degree burn to a specific portion of the arm, but it does have to be clear and precise and provide the government with notice that is in conjunction with the purposes of the statute, which again are to allow the government to properly set reserves, and depending on the nature and specificity of the injury, that might change, as Justice McCormick pointed out earlier.
I just find it odd that this, unlike some of the other notice statutes where they say nature of the injury, this one doesn't. So I don't know. I'm trying to make sense of that plain language and how it's different from other notice statutes.
Well, I don't even know if the court needs to go that far because here there was nothing presented whatsoever. So
well, they were pretty clear even in the cover letter about the severity of the injury, which I guess, in my sense, when I read Rowland and the goals of why it's important, that would make a difference in, sort of setting aside reserves if you knew it's a very serious injury versus a non. Like I could see how that would make a difference more than a body part. But I take your answer. You think it should be all three?
Yes, and I would say that is a reason precisely why this court should grant leave to appeal, to consider this, and to provide clarity to the bench and bar on this issue.
If we provide clarity to this, I guess what I'm trying to understand is the practicality of this in terms of how this would work. How do you respond to Brothers Counsel's argument that you're not necessarily aware of what the injury is going to be? Let's take a look at how a lawyer has to practice. You have 120 days, is that correct, to do this? Lawyer gets hired, when a person has a catastrophic injury, they're usually not going to hire a lawyer right after that happened. It might take them a little while to get to the attorney. And secondly, when you have an injury that's as severe as this, how is the person supposed to know the extent and level? I'm trying to, going based on the conversation you just had, how is one supposed to know the extent and level of the injury when injuries develop over time?
Right, and I would say to that the plaintiff needs to be precise about the injury as it is known. I'm not saying that the plaintiff has to have a crystal ball and anticipate how the injury might morph into something more severe over time, but within 120 days, the plaintiff surely has noticed that it was injured, to what part of the body is, to some degree of specificity, and that needs to be set forth in the notice so that the government can properly evaluate the claim and set reserves.
I just want to understand specifically kind of your contention as it pertains to this, because I guess I'm still a little confused as to what your position is, which is looking at this from a state jurisprudential level. If a person submits a police report or submits ambulance records, if they submit attachments, I just want to understand specifically from you, would you consider that to be requisite and that they would met the notice requirement?
If they merely attach documents and do not provide any indication within the four corners of the written notice itself as to what they're relying on the attachments for, I would say no, that does not meet the statute. But if they're relying on attachments to supplement and to provide further clarity, like in the example I gave with a picture of the defect showing the discrepancy
what if it comes
in the
in and
sidewalk.
it says, what if it comes in and it says, see police report, there's a, you enter that specific area that goes to the, location, and then it says, see corresponding police report. Would that be sufficient?
If I'm understanding your question correctly, if the notice provided maybe a somewhat imprecise description of the nature of the location of the defect and then attached a picture.
What I'm trying to understand is if I'm trying to answer notice and I submit attachments, and in the actual notice response I'm saying, please see corresponding attachment to answer question 2, which whatever might talk about location. So I'm trying to address to you the location, and then I say, please see corresponding document to address this issue. Would that be sufficient if the answer to the question is in an attachment to the material that I've submitted and I've sent you to that attachment in the document that's telling you to go there?
Then, yes, I think that is a closer question, might arguably satisfy the statute. But again, here the court need not reach that because we don't have that. We have documents unattached, as this court is well aware, and merely reference documents and not even with respect to the injury at issue. And that is inconsistent with the plain language of the statute. The plaintiff could have easily put the information in there and not leave it to guesswork. For those reasons, I would ask that this court either peremptorily reverse or failing that grant leave to appeal.
Thank you very much.
Thank
The case
you.
is submitted.